Greetings, Facebookers. Interference by third party, how to make them disappear. Purpose: to prevent the interference and trespass of a third party into your private contract. In your commercial activities, you may be met by third parties who wish to interfere with your private affairs. You must keep focused on the completion of every contract without being distracted by any outside influences, such as attorneys. Someone at a bank may have dishonored your instrument at one point, so you followed through with your private remedy and created a contract with the one who dishonored you. It is very important to have the name of the one who signed the instrument evidencing dishonor. You cannot make a private contract with a bank or other fictitious entities, corporations, in the private side, because you cannot see a fiction. You can only contract with a man or a woman that has signed a letter or other document, but you cannot contract with a fictitious entity. If you get another offer from a third party, namely an attorney, who is attempting to interfere with your private contract, then you must recognize this new offer as a separate offer. You cannot add the attorney to the first contract, as this is a different matter, and it also does not properly notice him as you have started your first contract before the third party interfered. Let us define some terms before continuing. Trespass: an unlawful interference with one's person, property, or rights. Any unauthorized intrusion or invasion or private premises of land of another. Trespass comprehends any misfeasance, transgressions, or offenses which damages another's person's health, reputation, or property. Criminal trespass. Criminal trespass is entering or remaining upon or in any land, structure, vehicle, aircraft, or watercraft by one who knows he is not authorized or privileged to do so, and A, he enters or remains therein in defiance of an order not to enter or to leave such premises, or property personally communicated to him by the owner thereof or other authorized person, or B, such premises or property are posted in a manner responsible likely to come to the attention of intruders, or a fenced or otherwise enclosed. Interfere: to check, hamper, hinder, infringe, encroach, trespass, disturb, intervene, intermeddle, interpose, to enter into or to take part in the concerns of others. Interference with contractual relationships. This tort has four elements: existence of valid contract, defendant's knowledge of that contract, defendant's intentional procuring of breach of that contract, and damages. Entry: practice means to place anything before court, or upon or among record or records, and is nearly equivalent to setting down formally in writing, either in full or abridged form, but it may be used as meaning supply to file or duly deposit. In criminal law, entry is the unlawful making one's way into a dwelling or other house for the purposes of committing a crime therein. In cases of burglary, the least entry with the whole or any part of the body, hand or foot, with any instrument or weapon introduced for the purpose of committing a felony is sufficient to complete the offense. Dwell: dwellin', to lead astray, stun, abide, dwellin', go astray, hinder, to live or stay as a permanent resident, reside, to linger over, emphasize, or ponder in thought, speech, or writing, to be motionless for a certain interval during operation. Instrument, a formal legal document in writing, such as a contract, deed, will, bond, or lease, a writing that satisfies the requisites of negotiability prescribed by UCC Article 3, a negotiable instrument or any other writing which evidences a right to the payment of money and is not itself a security agreement. If you happen to get an instrument in the mail from a third party which has entered the dwelling of the straw man that evidences a right to payment of money, such as a letter from an attorney, then it is time to accept his offer and create a contract with the intruder. Maintenance, lawsuit, or lawsuits. An obscocious intermeddling in the lawsuit by a non-party by maintaining, supporting, or assisting either party with money or otherwise to prosecute or defend the litigation. Bartery, the offense of frequently existing and stringing up quarrels and suits, either at law or otherwise. In maritime law, an act committed by master magistrates or mariners, attorneys of a vessel, your straw man, for some fraudulent or unlawful purpose contrary to their duty as a trustee to owner you and resulting in injury to owner. Creating a contract. 1. Notice of acceptance of contract. 2. Notice of default. 3. Notice of dishonor from notary public. 4. Certificate of dishonor from notary public. And 5. Default with an opportunity to cure. The following steps are sequences of events that must occur to get your contract established and enacted as the supreme law of the land. 1. Notice of acceptance to contract. Word process the notice of acceptance to contract for all of the correct information. Print the notice of acceptance to contract out. Read it several times for correctness. Stamp the offer with your acceptance for value stamp and sign it. Then get the notice notarized. Send the notice of acceptance to contract by registered mail. Return receipt so you have proof that they receive your contract you are in the process of creating. Send the copies of the above documents to the respondents and keep the originals, because the originals have all the power. Notice of default. After 10 days, send them a notice of fault. This notice completes your court procedure as a sovereign in your nation that is foreign to the public venue. Now you will need to pursue this matter in the public venue in their legal proceedings. However, it will not go into the court you are familiar with. You must take this matter up with this Secretary of State of the state you are in. Secretary of State in American law, title of the Chief of the Executive Bureau of the United States called the Department of State. He is a member of the Cabinet and is charged with the general administration of the international and diplomatic affairs of the government. In many of the state governments, there is an executive officer bearing the same title and exercising important functions. In English law, the secretaries of state are cabinet ministers attending the sovereign for the receipt and dispatch of letters, grants, petitions, and many of the most important affairs of the kingdom, both foreign and domestic. Black's Law, 4th edition. You are a foreign nation in their eyes, so you must go through the proper channels so that you can utilize the functions and duties of the Secretary of State, general administration of the international affairs, and attending the sovereign. There are many designees of the Secretary of State in the area you live in, normally called notary publics. Find a private notary public that you can work with, or create one getting a friend to become a notary who understands this procedure. So basically cultivating a notary, because even if they are a notary for the Secretary of State, it's highly unlikely that they've actually realized how much authority they have, and they probably haven't studied private administrative procedures. So it's going to be upon you to train your friend's family or notary that you find or cultivate in these processes. Notice of dishonoring, notary public. Now, we will go through the process called the notarial protest, a very powerful process that will create a witness against the debtor through a public official. Following is the definition of a notary public according to Black's Law Dictionary 6th edition. It is important to know why you need to use a notary public. Notary public, a public officer whose function is to administer oaths, to attest and certify by her or his hand and official seal certain classes of documents, in order to give them credit and authenticity in foreign jurisdictions, to take acknowledgments of deeds and other conveyances and certify the same, and to perform certain official acts, chiefly in commercial matters such as a protesting of notes and bills, the noting of foreign drafts, and marine protest in cases of loss or damages. One who is authorized by the state or federal government to administer oaths and to attest to the authenticity of signatures. Black's Law 6th edition. Pursuant to the Arizona Revised Statute, ARS, Title 41-332, Secretary of the State, Deputy County Clerk functions. Each clerk of the Superior Court shall deputize the Secretary of State and the Secretary's designees as deputy county clerks of the Superior Court solely for the performance of the Superior Court clerk's function. In summary of the above definitions, a notary public is a commissioner designated by the Secretary of State and deputized to be a deputy Superior Court clerk to hear certain issues presented to them by foreign agents by taking depositions of the parties termed notes. In order for the notes, contracts, to be binding, they are registered in the public record. 4. Certificate of Dishonor. Notary Public. If in 10 days the notary public does not receive a response point for point by affidavit with documented evidence, the debtor has defaulted and therefore dishonored your acceptance. The notary prepares a notarial protest, which the notary keeps for his own records, and issues you a certificate of dishonor. The certificate of dishonor is similar to a default judgment in the Superior Court. 5. Default. Now that you have a default in your private venue and a default in the public venue, and the respondent has assented to the terms and conditions by his silence, the respondent has become your debtor. You can now liquidate the debtor's property. You will write the default in an affidavit for summarizing the action of what you have done to this point. The purpose for this document is to enter this matter into the public record so that one may begin to foreclose or otherwise enforce the claim, which at this point will be liquidation. UCC 9-601 rights after default. A. Rights of a secured party after default. After default, a secured party has the rights provided in this part and except as otherwise provided in Section 9-602, those provided by agreement of the parties. A secured party, 1, may reduce a claim to judgment, foreclose or otherwise enforce the claim, security interest, or agricultural lien by any available judicial procedure, and UCC 9-607, collection and enforcement by secured party. B, non-judicial enforcement of a mortgage, if necessary to enable a secured party to exercise under subsection A3 the right of a debtor to enforce a mortgage non-judicially. The secured party may record in the office in which a record of the mortgage is recorded. 1. A copy of the security agreement that creates or provides for a security interest in the obligation secured by the mortgage, and 2. A secured party sworn affidavit in recordable form stating that A default has occurred, and B, the secured party is entitled to enforce the mortgage non-judicially. Your contract is the security agreement. The affidavit entitled Notice of Default is the sworn affidavit in recordable form stating that a default has occurred. UCC 9-609 secured parties' rights to take possession after default. A. Possession, rendering equipment usable, unusable, disposition on debtor's premises. After default, a secured party, 1, may take possession of the collateral. And B, judicial and non-judicial process. The secured party may proceed under subsection A, 2, without judicial process, if it proceeds without breach of the peace. Now that you have completed your non-judicial process, you can collect the collateral and take the possession of it. This is a work in progress. It is certain that there will be improvements to this process, and we will strive to get the information to you. In the meantime, learn it, improve on it yourself, and spread it to everyone you know who is determined to be responsible for the creation of their world. Now, there's some things that have been left out in this process. Obviously, you got a certificate of service, you got a certificate of non-response. If you're going to execute a process like that, it'd be highly recommended to use registered mail numbers or registered mailings, and that makes your federal postmaster a witness as well through the notarial process. So you have 2 witnesses, you have a state witness and a federal witness. Choice is really yours. Notice of acceptance to the contract. Arizona versus Pima County. Notice to agent is notice to principal. Notice to principal is notice to agent. I, John Henry Doe, hereinafter secured party, am competent to state the matters included in this contract which are true, correct, and complete, and not meant to mislead. Statements of fact. On September 15, 2002, secured party sent a document draft to the Shyster Bank for adjustment and set-off. As professional banking agents, they knew or should have known that a collecting bank must follow documentary instructions, or they are liable for the face value of the draft, plus any damages that may have occurred. On September 25th, 2002, secured party received the documentary draft back to him by mail, evidencing dishonor. The bank personnel did not follow instructions sent by secured party to process the transaction. 3. On October 11, 2002, secured party sent a notice of error and requested for investigation to Deborah N. Benda, DBA Vice President of the Shyster Bank branch on 6257 East Broadway. The notice requested Brenda to follow banking laws specified in Title 15 U.S.C. 1693H to initiate an investigation into this matter. Brenda has not responded to the above request, which puts them in default, and has now agreed to compensate secured party to the tune of $600,000. On October 19, 2002, secured party received an offer from a third party to interfere and trespass on private contract between secured party and Benda. The person who signed the offer to contract is Robert W. Burns, DBA, attorney for Shyster Bank, hereinafter respondent. Secured party hereby timely accepts the offer to contract from respondent and herein state the terms and conditions. Terms and conditions of the contract. 6. If respondent chooses to trespass or interfere in any manner whatsoever with the private contract between Barrett and secured party 03001 SWS DNW, which is really the expression of a trust. It's a constructive trust or a resulting trust from the initial contact and the delinquency of Brenda, who's a trustee on behalf of her principal, the bank. When he agrees to compensate secured party for $100,000 within 10 days. In the event respondent does not deliver $100,000 to the secured party within 10 days, as agreed to in this contract, respondent agrees to compensate secured party for triple damages in the amount of $300,000 thereafter, and may be subject to a involuntary bankruptcy in his private capacity to settle the account, which means a 433A and a 433B would be utilized to gain the knowledge of his personal assets and his business assets, because we all know they're not independently bonded and insured like they should be. In the event respondent withdraws his offer to contract within 10 days, then this contract will become void and secured party will not proceed with the enforcement of the above terms and conditions. It has been said, so it is done. Signed, sealed this day in 2003, John Henry Doe. Now, there's a little bit about this process I don't necessarily agree with, but there are some key points to learn from here. And one of them is the fact that if you never try, you will always fail. So, and you'll never have the answers that you're really looking for, because if you never attempt, you can never fail, which means you can never succeed. All right. So there's just a little bit about this process that I don't necessarily agree with, but at the same time, the information within here is good enough to bring forward to you guys. This is a notice of default. Now, again, I do a polite correspondence first, then a notice an opportunity with the intent to sue Neely DC, then a letter of fault, then a letter of default with an opportunity to cure. And I give them more than 10 days, although if they're the ones bringing a claim against you, they should have all the facts and evidence. And so technically when you do an inquiry as to what they're doing, you conditionally accept provided proof of claim, you could actually technically give them 3 days. They're supposed to have all that information. I'm not saying this info is not valuable. I'm saying it is most likely overkill for 90% watching. That could be true, Mike. But again, you know, the art of war. Study your adversary to a higher extent. I mean, I've got some other stuff that I was reading tonight that it'd rock a lot of people's worlds, and unfortunately, they probably wouldn't be able to keep up with it. Notice is hereby given that the above named respondent are in default upon the contract entitled Notice of Acceptance of Contract dated October 19, 2002, and therefore a default has been entered upon them by the terms and conditions of the agreement contained in the secured party's affidavit. You are under obligation to timely and in good faith protest and make proper presentment with proof of your claim or interest. Your failure to do so is dishonor and place you at default. By your default, you are deemed to be under new terms and conditions of our original contract and have therefore waived all of your rights to your original presentment and terms. Any attempt to collect on your original presentment places you personally at risk for any damages incurred per this contract and may subject you to criminal sanctions and involuntary bankruptcy. You are given 10 days, and again, I extend a little more than 10 days, and I also give the courtesy of 3 days mailing. And then, of course, if you need extra time, I also extend that. I mean, there might be a death in the family. I extend that courtesy because if I was involved in something like this and I had a death in the family, I would expect them to extend me that grace. So I also, in turn, would extend them that grace as well. So in equity, if in order to receive equity, you must do equity, right? So we're going to give them that benefit of the doubt. This document in particular is not, but that's how I structure things. You're given 10 days to respond. Final judgment is made by sending an original affidavit to the specified notary public as a third party who's a disinterested party in this matter, public official witness, and it's dated and signed. Notice of assent. Dear Burners, I received a request to be a third-party witness pursuant to the Arizona Revised Statute at Section 473505A for John Henry Doe, who informed me you have not responded to his acceptance to your offer to contract. The contents of the contract that he stated that he sent you consist of the Notice of Acceptance to Contract dated October 19, 2002. So a lot of this, ladies and gentlemen, is about dictation and keeping good notes. And Notice of Default dated November 3rd, 2002, which brings up a very good point. If you're going to execute a process this intricate, it's a very good idea to go out and get yourself a big calendar so you can write everything down on the calendar to put your process together all the way through. So once you start it, you know that all your envelopes are sealed, all the information is in it, and you can just literally mail your letters out as the days come on the calendar, okay? And that way you don't miss any process, and it's done properly. Or if you're having a notary do it for you, sometimes your notaries can have error in their process because they lack the skill or the knowledge and understanding. So go ahead and create that map for them on a big calendar and make sure that all the envelopes are on that need to be sent out or stuck on the exact day that they need to be stuck out. And also make sure that you have a calendar so you can call your notary and say, hey, today's the day that the second notice needs to be sent out, the letter of fault, and let's make sure to get that done today, please. Time is of the essence, and we don't want to shirk our dereliction. We don't want to be found in a dereliction of duty and not following through with the process 100%. The notice were sent to you at 105 East Speedway, Phoenix, Arizona, 85684, as evidenced by U.S. Postal Service certificate of mailing, okay? So earlier today on Facebook, I posted a couple posts about insurance companies, and when they cancel your insurance, there are certain parameters that they must meet, and one of those is the fact that it either needs to be registered mail or certified mail. It can't just be sent out in bulk mailing. That doesn't constitute notice, okay? And so if it's good enough for the insurance companies, then it's good enough for us, all right, ladies and gentlemen? And that's the importance of learning certified mail, return receipt, requested signature, and verification of party. You can go into that depth and detail if you like. You got your 3877, your 3811, your 3806s. You really need to pay attention to those forms and understand the power that they have, and also your registered mailing, okay? In the event you acquiesce, your acquiescence was unintentional or due to reasonable neglect or impossibility, I am attaching a copy of the same presentment to this notice. You may respond to me, and I will forward your response to John Henry Doe. So this again is the notary coming in and stepping up to the plate saying, hey, look, we understand something may have come up, death in the family. You may be not at the address where the mailing was sent to, whatever the case may be. She's giving him a little bit of leeway. She's extending to him equity, grace, forgiveness, leniency, which we all want. And I've seen so many people seriously harm their own case with this stuff. All right, Mike, well, if you don't like it, jump off, buddy. I don't know what to tell you, man. I'm here to tell you, I'm working on case number 15 now. Case number 15, and I haven't had to go to an appellate court not once, buddy. Not once. So there's something to be said about that. And right now, it looks like I'm going to pull off another great victory with the Heavenly Father in the state of Iowa, where there will be no need for an appeal, and the alleged judge is taking it under advisement for 3 weeks. I mean, it's an open and shut deal. It's a territorial jurisdiction, and they ain't got it. Not a prayer. And of course, it's a young prosecutor who's 30 years old, who's got something to prove, who alleges that she's a peace officer and can't produce her certificate of good standing of being a peace officer, or a foreign registration certificate compliant with the Foreign Registration Act of 1938. She's not independently bonded. They haven't bonded the case. There's just a litany of things going on here, Mike. So, I mean, I can appreciate what you're saying, and at the same time, go for it. Woo us with your knowledge. I'm not opposed to it, but at the same time, there are people here that do gain from this. And I read everything, because even in the most ignorant document, I will find something of great value, either a method for not doing something, or maybe there's just one sentence or one key phrase in there that I pull, one maximum that's worthy of reading 150 pages. So, you speak truth, and you have my respect. You have my respect as well, Mike. In the event your acquiescence was unintentional or due to reasonable neglect or impossibility. Now, impossibility is something that, not everybody can determine. So, again, you have to be reasonable. You have to be courteous. I mean, the reason these people are running amok over us is because we have just flat out fell out of the sense of practical application. I'm attaching a copy of the same. So again, extending grace, courtesy, and attaching another copy just to make sure that they have a copy of what was originally sent. Presentment to this notice. You may respond to me, and I will forward your response to John Henry Doe, and the importance of that is a disinterested third party. The notary is a disinterested third party. He or she has no interest in the subject matter, just following a process. That's it. That's their job. They're not to intervene. They're not to make it personal. They're not to have any influence in the outcome. But as you see here, this is the notary making a valiant effort to establish, hey, we know that you've received this. I've got return receipts from you receiving this, and just in case the correspondence was lost, here again in good faith is another instrument just to make sure that you have it. And that really weighs heavily in your favor, getting your declaratory judgment, your summary judgment, your writ executions, because you can show that in good faith you put a valiant effort in there to make sure that they were properly served. Your response is expected no later than 10 days from the postmark of this notice of assent. Thank you for your prompt attention to this matter. Sincerely, Notary Public, okay, with the stamps. Certificate of Assent. I, Dina L. Baker, am a notary to whom all communications are to be mailed regarding the contracts entitled Notice of Acceptance to Contract Number, and that's, again, the number either the gentleman put on there or the original mailing of the first contract that was sent out to him that he was responding to. And it's number 92501 JHD. Looks to me like he put his own number on there. JHD, John Henry Doe, would have been first initial of each name, first, middle, and last. And that's just a great way to create an identifier for you and your documents. Again, a lot of this is based upon dictation, keeping good notes, and having your shit wired tight and your head on a swivel, all right? Here in contract. Pursuant to the Arizona Revised Statute 473505B and the Uniform Commercial Code 3-505B, notice of protest is hereby given with certificate of dishonor regarding the following. On November 23, 2002, I mailed you a notice of dishonor to Robert W. Burns, DBA attorney with Shakedown Law Firm, giving respondent 10 days to answer. As of this date, no response had been delivered to me. The designated receiver, I interviewed John Henry Doe, whose affidavit is attached to this notarial protest. John Henry Doe has stated to me by affidavit that petitioner has received no response to said contract at any other mailing location. Based on the foregoing information, respondent has dishonored John Henry Doe's contract by non-acceptance and or non-performance, and have therefore assented to the terms and conditions in said contract. So by their silence, they acquiesce by tacit agreement. And something that's important to note about this is exactly how they get you into contract, ladies and gentlemen. You get the mail and you shirk your responsibility and you throw it in the trash, and all of a sudden the collectors start calling you, and you might answer the first few phone calls, and then every time they call you ignore it, and you ignore it, and you ignore it. And I'm going to tell you something. I got some friends that are collection agencies, or excuse me, they're not collection agencies. They are actors who work and perform on behalf of a principal that is a collection agency, okay? So they're trustees tasked with the duty of collecting debts. Debts are valuable. Debt is money. Debt is an asset, okay? Many of us look at debt the wrong way. I myself was guilty of it for quite some time. And so there's a reason that they're pursuing this debt, because this debt is valuable, okay? You have credits and you have debts, and that's your ledger system, your T-ledger system. And there's another way of looking at it, but essentially what I'm trying to say is, after 180 days of them coming after you and you not responding, and they default you and they can prove that they properly served you, guess what? Even if you were to show up in court to try and fight them, you've already lost. It doesn't matter what you say. It's over. And so this is kind of how I learned this process too, was by watching a credit card company default me. And when they defaulted me, I was like, aha, I see how they do it. They just send a bunch of shit in the mail frivolously, at least I thought it was frivolous, although they don't do it correctly. And even my buddies that are in the collection agency business, they tell me, Derrick, because of your acquired knowledge, we'd have a really hard time proving that we properly served you because we use Pitney Bowes stamps. We don't ever send anything certified. We don't send anything registered. We don't send anything priority mail. And because of that and your knowledge, more than likely we'd have a really hard time proving that we had actually served you. But they hang their hat upon the fact that once an article mail has reached the post office, it's been considered served. But when we go back and we look at some of the other cases in the Supreme Court where they're saying the insurance companies can't technically terminate your insurance without proper service of process, and they're telling them that they have to use certified mail and registered mail in order to do that with return receipts and stuff to prove the fact that they actually served it. Not only that, but they also have to prove what document was in the envelope before it was sent. And that's another story for another day, but it's just food for thought to keep you guys thinking about how this actually works. Notice to agents is notice to principal, and notice to principal is notice to agent. The parties to the contract entitled notice of acceptance to contract hereinafter contract are in full agreement regarding the following. I, John Henry Doe, hereinafter affiant, am competent to state to the matters included in this declaration, have knowledge of the facts, and it's first-hand perfected knowledge of the facts, and declared that to the best of my knowledge, the statements made in this affidavit are true, correct, and not meant to mislead. All right, and there's a lot to be said in here, because when we're saying it's true, correct, and not meant to mislead, we're showing our intent, we're showing our purpose, right? We're coming with clean hands, good faith, and for good reason, and those are really the teeth in your document. We always are doing things in good faith, with good conscience, and for good reason. And that really is the substance that gives you a hell of a punch when dealing with other people. Robert W. Burns is herein addressed in his private capacity, in his public capacity, is a citizen and resident of the state of Arizona and is participating in a commercial enterprise with his co-business partners, including but not limited to Shakedown Law Firm, hereinafter collectively referred to as a respondent. The governing law of this private contract is the agreement of the parties supported by the law merchants and applicable maxims of law. Affiant at no time has knowingly, intentionally, or voluntarily agreed to subordinate their position as creditor through signature, words, actions, or inactions. 5. Affiant is not a party to a valid contract with respondents that requires affiant to perform in any manner, including but not limited to the payment of money to respondents. On October 19, 2002, secured party received an offer from a third party to interfere and trespass on a private contract. The person who signed the offer to contract is Robert W. Burns, DBA, attorney for Shyster Bank Loan Department, hereinafter respondent. On November 23, 2002, Diana L. Baker, a public notary, mailed a notice of dishonor to Robert W. Burns, DBA, attorney with Shakedown Law Firm, giving respondent 10 days to answer. On December 10, 2002, I received a certificate of assent from Diane L. Baker, the designated receiver for respondent, stating that she had received no response from respondent. Affiant sent notice of fault and default, allowing respondent additional time to respond. However, no response has been received. So respondent has fully agreed to all of the terms and conditions of the contract, including the compensation to affiant for the total of $300,000. It has been said, so it shall be done. Dated this day in 2003, John Henry Doe, Arizona, Pima County, acknowledgement as a notary public for said county and state. I do hereby certify that on this day of this year, the above mentioned appeared before me and executed the foregoing, witness my hand and seal. Enacting the contract. Purpose. The purpose of this procedure is to file and perfect the claim that you have against a debtor if they have dishonored you or your acceptance of their offer, and enact it as law. Before starting this process, one must have accepted all offers given to them, completed the administrative procedure, including the notarial protest, and now have a secured claim against the debtor. This procedure starts once you have a certificate of dishonor from the notary, which is as valid as a default judgment in a superior court in the state of Arizona, at least. Bankrupt, bankrupt, L bank a bench plus rups, broken. Literally one whose bench has been broken. The bench or table which a merchant or banker formerly used in the exchange having been broken on his bankruptcy. The Consolidation Webster's Encyclopedia Dictionary, 1939 edition, bankrupt, originally and strictly a trader whose secrets himself or does certain other acts tending to defraud his creditors. In a looser sense, an insolvent person. In English law, there were two characteristics which distinguish bankrupts from insolvents. The former must have been a trader and the object of the proceeding against, not by him, as used in American law. The distinction between a bankrupt and an insolvent is not generally regarded. Do you find it interesting that a bankrupt is one who acts to defraud his creditor, who fits the description of a trader and who is the creditor? Trader, one who makes it his business to buy merchandise, goods, or chattels to sell the same at a profit. One who sells goods substantially in the form in which they are bought. One who has not converted them into another form of property by his skill and labor. The above definitions for bankrupt or trader could not be found in Black's Law 6th edition, and here is probably why. What institution do you know of sells chattels substantially in the form in which they are bought? Herein a hint. What does the bank do when they deposit your promissory notes as an asset instead of a liability, then writes a check off of the deposit to give to the seller of the property? First of all, the bankers do not buy your credit with money. After you give your credit to them, they sell your credit to the seller of the property without converting it into another form. It goes in and comes out the same, your credit, or as they would say, money. Could this be considered of the bank to be an act to defraud his creditor? Bankrupt law. The leading distinction between a bankrupt law and an insolvent law in the proper technical sense consists in the character of the person upon whom it is designed to operate. The former contemplating as its objects bankrupts only. That is traders of a certain description, the latter insolvent in general, or persons unable to pay their debts. This has led to be a marked separation between the two systems, in principle and in practice, which in England has always been carefully maintained, although the United States it has of late been disregarded. The only substantial difference between a strictly bankrupt law and an insolvent law lies in the circumstances that the former affords relief upon the application of the creditor, and the latter upon the application of the debtor. Why do you think the United States has failed to maintain the difference between bankrupt and insolvency? I have a theory. Since they call you bankrupt, they are assuming that you are acting to defraud your creditor, and therefore you are in dishonor before walking into the courtroom, and that you are considered a criminal by the mere fact that you filed your bankruptcy petition. Following in step-by-step set of instructions that will assist you in your taking the equity from your debtor's note. This is only an example that has been used to take property. One will still have to continue processes to keep it. This procedure will, of course, be improved from time to time, but it is good. But it is a good place to start. Step 1, sequence 1, notice of substitution of trustee. Because the banker has a trustee that's working on behalf of the bank and not you, so you need to turn around and fire that trustee through either doing a quit claim deed process, quiet title action. That way you can remove the trustee. Also, if you do an inquiry to the bank and they can't respond, you fault and then default them, do a declaratory judgment which establishes the rights of the party. You can then move into a summary judgment, do writs of execution, writ of liquidation, writ of garnishment, so on and so forth. Number 2, collateral found. Number 3, substitution of trustee. Number 4, UCC1 assigned. Number 5, notice of disposition. Disposition. Number 6, disposition real property. Number 7, disposition personal property. Number 8, disposition of vehicle. Number 9, confirmation of receipt of recording and filing. Notice of substitution of trustee. Information. An accusation exhibited against a person for some criminal offense without an indictment. An accusation in the nature of an indictment from which it differs only in being presented by a competent public officer on his oath of office instead of a grand jury on their oath. Functions of an information is to inform defendant of the nature of the charge made against him and the act constituting such charge so that he can prepare for trial and to prevent him from being tried again for the same offense. Black's Law Dictionary, 6th edition. Notary public. A notary public officer whose function it is to administer oaths, to attest and certify by his hand and official seal certain classes of documents in order to give them credit and authenticity in foreign jurisdictions, the noting of foreign drafts. Operating outside a bankruptcy proceeding is considered to be a crime according to Title 11 U.S.C. Any public official who is aware of an activity evidencing unlawful operations must report such activities to the proper authorities such as the U.S. Attorney or the U.S. Bankruptcy Trustee, Paul H. O'Neill. Now, this was done in 2003, so I'm not sure that Paul H. O'Neill is still there. You'll have to do your due diligence to reference this information and make it effective. An information is an accusation exhibited by a public official. Since a notary is a public official and has first-hand knowledge of the crime by doing a notarial protest on that person, the notary must report such activities by information. The information will be in the form of a certificate of dishonor issued by the notary that will include all previous notices and evidence of noticing that you have done since the beginning of the matter. The information will be written by you and will contain all details and specifics on such activities and must be in an affidavit form in order for a criminal complaint to be initiated and the matter investigated by the U.S. Attorney or any other agency with a duty to handle the matter. Acceptance supra protest. Acceptance for honor. The acceptance or payment of a bill of exchange after it has been dishonored by a person wishing to save the honor of the drawer or an endorser of the bill. Dictionary of Business, Oxford University Press, Market House Books, Ltd., 1996. Supra protest. In mercantile law, a term applied to an acceptance of a bill by a third person after protest for non-acceptance by the drawee, Black's Law, 4th edition. The second purpose for sending this document is to allow all of the notified parties an opportunity to accept for honor. This package is to be sent to the trustee of the United States Bankruptcy, Paul H. O'Neill, so they can investigate why the debtor is unlawfully using your exemption and operating outside the U.S. bankruptcy. If this third party who represents you, the creditor, does not wish to save the honor of the debtor, a subcorporation, or the U.S., you will put the debtor into involuntary bankruptcy. You will give them 10 days notice to the proper authorities in order to accept for honor or handle this situation. If they fail to respond, their silence is their consent for you to administrate and conclude the involuntary bankruptcy in a foreign proceeding. Your court, as a foreign nation, this is pursuant to Title 11 U.S.C. 303b4. At this point, the state, United States, or all of their agents cannot come back to you and bring up the fact that you did not have the authority to liquidate the debtor's property. The third purpose of this document is to give Paul H. O'Neill, the Chapter 11 Reorganization Bankruptcy Trustee, a notice of substitution. Being a Chapter 11 trustee, he fails to qualify to commence with any Chapter 7 liquidation proceedings, so he must be substituted by another who is qualified to do so. Title 11 U.S.C. 703 Successor Trustee. A. If a trustee dies or resigns during a case, fails to qualify under Section 322 of this title, or is removed under Section 324 of this title, creditors may elect, in the manner specified in Section 702 of this title, a person to fill the vacancy in the office of trustee. Since the proceeding is foreign, you would not need a person to fill the vacancy in the office of trustee, because why? A trust will not fail for want of a trustee, okay? You would elect or assign a private trustee yourself. Substitution. Putting in one person in place of another, particularly the act of a testator in naming a second devisee who is to take the bequest either on failure of the original devisee after him, Black's Law 4th edition. Testator, one who makes a will. Devisee, a person to whom lands or others' real property are devised or given by will. In the case of a devise to an existing trust or trustee, or to a trustee on trust described by will, the trust or trustee is the devisee, and the beneficiaries are not devisees. Devise, a testamentary disposition of land or realty by the last will and testament of the donor, to dispose of real or personal property by will. You may be asking, what does a will have to do with bankruptcy or trust? Or who died leaving you in charge anyway? One must remember that the debtor is a trust created by the state in order to keep an accounting of all the credit they are using in the creditor's name. It is just an account with the debtor showing how much the state of the United States is liable to the creditor, the real man or woman. And with that being said, I just wanted to say we have an awesome class coming up May 15th at 1 p.m. Central Time. And if you guys would like to join, I'll throw a link in here. We're going to be delving into things a lot deeper than this, but I just kind of wanted to get this in your guys' head now so you can start to think about private administrative process, how to protect your friends, your family, your loved ones, your community, your fellow countrymen that you love and adore so much, and help them see the truth. The truth is, you have to be an ambassador of peace. Stop going to war. Learn contract law. Understand trust law. And you really can prevail. You really can make a difference. You are the creditor. It's been upheld many times in the Supreme Court. I was just talking to a banker at Wells Fargo today, and he was blown away. He was absolutely smitten by the information I was giving him. And he just kind of looked at me. 2 nights ago, we were at a small diner And by the time we had left, the whole staff was out of the kitchen and at the payment counter and literally just sitting there going, give us more information, give us more information. And it was just so brilliant. These young kids, I think they were like 16, 17, 18 years old. They were being managed by a 40-year-old woman. And by the end of us discussing all this with them, they were all at the counter and they were so enthusiastic about, hey, how do we gain more of this knowledge? Where do we find it? This is very intriguing. You mean to tell us that our social security number and our W-4 and our W-2 forms and everything, that's how we're getting paid? We're actually not getting paid by the owner of the company. We're actually paying ourselves through our own exemption accounts and stuff, and we have a right to recoupment? Yes, you do. Yes, you do. And it was just so empowering to see these young kids willing to absorb it like a sponge and being very, very enthusiastic to gain that superior knowledge. Everything is a tax issue, ladies and gentlemen. Everything, after all, is an excise tax. I mean, just buying this soda, I paid an excise tax, and I have a right to recoupment of that excise tax. It's just a matter of learning Title 26, Title 27, Title 28. But also to learn how to accept and acknowledge the contracts. A lot of times people don't realize that when you dishonor something, now you become the debtor, and your actions create a trust. Your words create a trust. You can create a trust in written form. Okay, you've got implied trust, resulting trust, constructive trust, and it's important to learn these things, these mechanisms on how commerce is done, how trusts are formed, and the important thing is how to remain in honor at all times. We always want to do things in good faith, with good conscience, for good reason. So I look forward to seeing you guys May 15th, 2021 at 1 p.m. Central Time. And I'll post a link in this video for you guys that wish to join, that haven't signed up yet. It's a $100 donation. Really cool. But thank you very much this evening for joining me. Just wanted to give you a little brief on the kind of work and research I do on a day-to-day basis to help you guys ascend to the mind and really put your best foot forward and not be so intimidated by lying, looting, pandering piece of shit lawyers who are there just to unjustly enrich themselves based upon your ignorance. So thanks again for joining me, and I look forward to seeing you guys May 15th, 2021 at 1 p.m. Central Time for the class that will be held on Zoom. And we're going to be teaching people about mortgages. We're going to be teaching new homeowners how they can come in and qualify their endorsement, protect their investment, protect their interest in their note and their property. So we'll see you guys soon.